So thank you, Owen. I think I should begin with a few words about the title here, because the session does indicate we're talking about international wildlife management and enforcement. And I thought that when I was asked to participate in this, I could just talk about international treaties, the actual text of the treaties rather than the domestic stuff. And then I think it was either Martin or Alan who drew my attention to the fact that the overall title of the conference is Environment in the Courtroom, Enforcement Issues in Canadian Wildlife Protection. So reflecting on that, I thought, well, oops, I better focus on some domestic law here, and I picked WAPRETA. And then, of course, I showed up this morning, and the first slide that goes up says that these federal guys are going to spend all this time talking about WAPRETA. So I thought, well, I might as well just go home. But then I sort of collected myself together and thought, well, maybe I still have some value to add. But there will be, I confess, some overlap with what we've already heard, but this is just going to reinforce the importance of international law in all of this. Anyway, here's the outline. I'm going to talk about the purpose of the Act, the purpose and scheme of CITES, spend a moment referring you to some, I think, valuable resources worth looking at, then talk about the interpretation of the Act, and then get into some more detail on the scheme of the Act. The paper doesn't deal with sentencing decisions. We heard something on sentencing from Erin this morning and indicating how much those provisions have been beefed up in recent years. But there are a couple of references there to recent sentencing decisions. And yes, as Martin observed, many of them are unreported, but I'm sure counsel in those cases will be happy to share the materials they put before the court. Anyway, the purposes of the Act. I think one of the speakers this morning, I think it was Alex, said there are two purposes. One is implementation of CITES, the Convention on International Trade in Endangered Species of Wild Fauna and Flora, which entered into force, was negotiated in 1973, entered into force in 1975. It is perhaps the most broadly ratified multilateral environmental agreement that there is. The legislation, of course, doesn't come into force until 1992, which tells you there was a bit of a gap which was filled by the federal government relying upon the general export and import permit legislation, and then we got this more specialized legislation. The second thing the Act does is to reinforce provincial rules on interprovincial movement of wildlife and plants, and Alex mentioned that. But there is also this third purpose in that it can be used, as they put it in one of the federal publications, to protect the Canadian ecosystems from undesirable species. So this is the idea of listing particular species which are considered to present threats to natural, local biodiversity, and I'll give you one example of that later. But I think that's sort of an important third purpose, which may become more important over time, I think. So the scheme of the convention, again, some repetition from this morning, but the convention aims to restrict and regulate trade in listed species. If it's not listed, CITES has absolutely nothing to say about a species. And you get listed by being identified as threatened or endangered. But in addition, there must be established that trade is playing a part in the reason why this species is threatened or endangered. Unless you can establish the trade significance, then you shouldn't get listed under CITES because it's concerned solely with trade. There are no habitat protection provisions in CITES. It focuses entirely on trade. Appendix 1 species threatened with extinction, export and import permits required from the state of export and the state of import. And the general intention of the treaty is that there shall be no trade for commercial purposes in Appendix 1 species. Appendix 2 species, threatened species, requiring only under the convention a permit from the state of export, which, and this is an addition from this morning, should be based on a finding that the species is both lawfully taken and that the take of that species will not cause a detriment to the survival of that species. So it's the so-called NDF finding. And so how would this work? Well, we continue to permit export of Appendix 2 listed polar bears. Canadian Wildlife Service issues a statement, a paper to the effect that we think we can do this without causing a detriment to polar bear populations because we think we're managing those on a sustainable basis. There are subpopulations of polar bears. We do an analysis as to an appropriate level of harvest. We get commitments from the relevant communities that share that subpopulation of polar bears, and they're harvesting within agreed quotas. Therefore, we can make this NDF finding. An example a couple of years ago where that finding was actually suspended for polar bears in the Kane and Baffin Basin, I think, shared with Greenland on the basis that the feds at that time thought we can't actually, because of we're not sure about total harvesting levels, make this NDF finding. And then the third appendix, the voluntary listing where a state requires assistance. And perhaps the best example for Canada is walrus, which we asked to be listed when the convention first entered into force. You need an export permit then from federal authorities, but interestingly enough, it doesn't need to be supported by an NDF finding. So that fine walrus tusk that was held up this morning would require a federal permit. And then I think, important for anyone who's working in this area, both domestically or internationally, to reflect on the fact that the CITES does have a complex administrative structure, like many multilateral environmental agreements, and in particular it has a conference of the parties, much like the scheme under the Framework Convention on Climate Change, but this one meets every 3 years, and it is responsible for listing new species, because of course when the treaty was first negotiated, there's a list of species attached, but then there has to be a mechanism for updating it, and the mechanism is through the Conference of the Parties, which can uplist, downlist, split list, whatever you like. And so as an example, the United States for a number of years has been proposing uplisting polar bear from Appendix 2 to Appendix 1. Canada has resisted that and has resisted it successfully simply on the basis that you cannot establish that trade is a threat to polar bears. Polar bears may well be threatened by climate change, but you can't really establish that there's a trade threat that's undermining the conservation status of polar bears. I think what's crucial about the COP, in addition to the listing process, is it's also responsible for elaborating on the text of the convention effectively, for coming up with agreed interpretations, for stipulating if we need permits, well, what form should those permits take so that we have some uniformity both in language and structure of these permits. So that would be one example. It's also spent time in recent years elaborating on what we expect from a state of export in relation to these no detriment findings. So some resources to think about. Well, CITES has a great website. You'll find more than you'd ever want there, I think, all fully documented. And of course, lots of great pictures of charismatic megafauna, as they like to call them. NDF reports, you can get them on an Environment Canada website, so you can see what they look like. Environment Canada, or Environment Canada and Climate Change, also produces an annual report on WOPR ITER, so providing material on permitting, providing material on enforcement actions, and again, a good resource. For those of you interested in following the evolution of the regulations, then I think one crucial source are these so-called regulatory impact analysis statements, the RIAS statements that must accompany all new federal regulations. And quite frankly, some of the changes to the regulations are impenetrable without going and looking at those RIAS statements. And then finally, ECCC, or EC3, I don't know how we're going to say it, but anyway, that department plays an important role in enforcing WOPR ITER and the regs. But you would have understood from this morning that the rubber really hits the road at ports of entry. And so the guys who are very much involved in enforcing WOPR ITER are customs officials. And so the Canada Border Agency has a memorandum talking about its policies and practices in relation to WOPR ITER enforcement. So I think also worth looking at. So interpretation of the Act. So there would be a school of thought that says, since the Act is principally concerned with the implementation of CITES, one should be looking at CITES in interpreting the Act, and indeed that it might be very persuasive in terms of interpreting the Act. There's at least some authority to suggest maybe that's not that simple in relation to CITES, in relation to WOPR ITER, and there are a number of reasons that have been given. One is that CITES authorizes states to go beyond the terms of the convention. And as we've indicated, both the Act and the regulations do exactly that. So we've got this one decision, fairly recent, Drouin and the Attorney General of Canada. It's unusually a federal court case. It's an administrative law case, then not a criminal prosecution case, but it's a case where the court declined to read in what is a general exemption in CITES. So CITES enters into force or was negotiated in 1973, and therefore perhaps not unreasonably says, if you can establish, or if you can get a state certificate establishing that this species, this specimen, was taken prior to 1973, then we should relax the permit requirements. So there isn't a blanket pre-convention exemption in the Act, but Drouin was trying to say, well, we should be able to read that in. And the court said no, that the absence of an exemption is consistent with the purpose of the Act. It's rational for Parliament to have concluded that it was not appropriate to incorporate the full exemption provided in the Act. And if you look at the regulations, they do provide a limited form of pre-convention exemption, but not the general blanket form which Drouin needed to succeed with his claim. So I think what the courts are saying is, we're going to interpret the Act and the regs as they stand. We might look at the convention, but it's certainly not going to have a lot of weight if it conflicts with the clear language of the statute and the regs. Okay, moving now then into more detail on the Act and following that list and starting, not surprisingly, with definitions. And definition's actually surprisingly hard for this statutory scheme, because when you look at the Act, you'd say, well, the Act only applies to convention-listed species. Look at the definition of plant, look at the definition of animals. It's in relation to those terms by reference to the convention annexes. But here's an Act which allows the regulations to redefine the terms plant and animals, and yes, the regulations do that with gusto. And they do it in relation to specific sections of the Act. So for the purposes of Section 6.1, plant means, or for the purposes of... So all of that suggests that it's a fairly complex structure. You do need to read the two together. And here's where we get this biodiversity provision being, or purpose being reflected in the regs, because the regs do permit additional species to be listed which aren't subject to the CITES regime, but for biodiversity protection. So here's an important amendment made in as recently as 2017, which prohibits without permit the import of any salamander. Why? Because salamanders in East Asia have been found to be carrying a fungus which is lethal to salamanders that haven't been exposed to this. So presents a huge biodiversity threat to North American salamanders. So the prohibitions, and again, we chatted a bit about this morning, but basically the main prohibitions are this prohibition on import in contravention of the law of a foreign state, so the illegal logging example that was referenced this morning. And of course, if that's what's being alleged, then as Alex pointed out, the onus will be on the Crown to both show that this is a covered specimen, kind of obviously that it's a listed species, and proof of contravention in some admissible form. And Alex, I think, gave some nice example with this Clement case. That was the Alaska bear case that he referenced, and the challenge of getting supporting evidence to allow the court to reach that conclusion. And then the more general requirement, no import of a listed species without a permit. And then these Section 7 provisions, which are really designed to, I put it this way, to federalize provincial requirements. So where the province has got its own permitting requirement, the WAPRITA regs add to that and say, if the province requires this, we're also going to be requiring this for federal purposes. Now, I'm not entirely sure why they do that, but one thought would be that those provincial laws might be vulnerable insofar as they're dealing with interprovincial trade and commerce. So here's a way of bolstering their effect, giving them federal effect that can be prosecuted as federal offences. So the speakers this morning, I think, talked about the difficulty of successfully prosecuting some of these cases. So here's a case dealing with the question of how you establish that you've got a listed species. Well, you might think that would be pretty straightforward, but think about the facts of this case. So Kwok Shing was an importer of traditional Chinese medicines, brings in lots of stuff on a regular basis, including these boxes containing Leiden tablets. Well, I don't know what a Leiden tablet is, so I Googled it, and it's something that promotes healthy function of the liver, gallbladder, bile passages, and intestines. So great stuff, I'm sure. The ingredients are listed in Latin and Chinese. The Latin says these are Radix sausurea. Sausurea is part of the daisy or thistle family. and there are more than 400 members of that family. And my Latin's actually good enough to say, I know radix means root, so that's not the hard part. But the only one of those 400 Saussurea species that's listed is this Saussurea costus, also known as Lapa, which is listed in Appendix 1. And on the basis of this labeling information, Kwok Shing is charged with importing without a permit a listed species under Section 2. Crown relies on this nice deeming provision in the regulations, which gives it some extra credibility, I suppose, but the court rules you don't even get to rely on Section 20. Why? Because you haven't established that the reference to Radix saussurea is actually a reference to this particular listed species. And the Crown's particularly challenged because the two officers it puts on the stand don't speak Chinese, don't understand Chinese language and symbols, and the case is thrown out. I think that tells you that in addition to all of the other experts that were referenced this morning, maybe you need a linguist to successfully prosecute some of these cases. Going on with the prohibitions, so with the no breach of a foreign law, need a permit, the provincial prohibitions, and then this one, no person shall knowingly possess something that has been imported or transported in contravention of this act, and then a bunch of other paragraphs. Unusually, this is a knowing one, right? This one then, there's authority that says this one isn't strict liability. The Crown in this case must actually establish mens rea. And interestingly, in the case that was referred to this morning as successfully prosecuted, which it was the Clement case. It was successfully prosecuted on the Section 6.1 grounds, but the Crown fails to establish a Section 8 offence because the court, I think it's a bit surprising because the evidence looks overwhelming to me, but the court held that the Crown hadn't proven its Section 8 charge. Clearly, permitting is a crucial part of the WAPRITA scheme, and there are provisions allowing for the issuance of permits, but if you are importing an Appendix 2 species, which is what most of the traffic would be, there's a general exemption, right? You don't need a Canadian permit because all you need is a permit properly issued by the state of export. And I would say a permit then that must also comply with the CITES standard requirements, which we talked about a moment ago, for those permits. We'll need a permit, though, where you've got a species that is listed for what I refer to as biodiversity reasons. Clearly, a permit from the state of export isn't going to cut it if we are concerned about biodiversity issues. There are a bunch of exemptions in the regulations, particularly in relation to Appendix 2 species. Those are based on exemptions in the Act, and they're very nicely discussed, I think, with examples in that policy document issued by the Canadian Border Authority. For exports, if you're exporting from Canada, then we need export permits, and they're going to come either from Environment Canada, from Department of Fisheries and Oceans, or by delegation from a provincial government authority. I see my federal colleagues have wandered in at this stage, so I hope I'm not going over too much ground that you covered earlier this morning. But anyway, the power to detain is also clearly a key authority of customs officials, Environment Canada officials in dealing with imports. And so Section 13 allows items to be detained until the official can satisfy himself, herself, that the thing has been dealt with in accordance with the Act. This has been subject to some interpretation in this Drouin case, which I mentioned earlier, which, as I say again, unusually is an admin law action rather than a criminal prosecution. So customs officers detain Inuit art items being imported by Drouin, who is a collector. These are tupeliks, figurines made from, in this case, it was determined sperm whale ivory. Sperm whale is an Appendix 1 listed species. There was no formal documentation from the Danish authorities. There's some kind of documentation, but it appears that this is something to be used within Europe rather than for export purposes. Anyway, the items are detained, and Drouin eventually seeks relief in the form of a judicial review of that decision to detain. And the case establishes a number of things. One, that the standard of review for that decision is reasonableness. And part of the argument why it's reasonableness, again, is that the Act is not solely concerned with the implementation of the Convention. If it were simply concerned with the implementation of the Convention, then there might be an argument that we need the Convention to be uniformly interpreted, and that would push us in the direction of a standard of correctness. But as we said, the court says no, the Act has got more diffuse objectives, and reasonableness is appropriate. And the court goes on to say then that both the original detention and the continued detention of the tupeliks was reasonable precisely because there wasn't a permit in proper form, but it was not reasonable in relation to the suggestion that it might have been detained on the basis of Section 6.1, which is the provision dealing with an unlawful something taken unlawfully under the law of another state. Why? Because here's an example where the Crown, it didn't need to because it wasn't prosecuting, presents no evidence of contravention of the law of another state. Therefore, it couldn't possibly be reasonable to keep the tupeliks detained on that basis. But, of course, the Crown only needs to win on one of those. And as we've indicated earlier, this was also a case where, I guess another reason why it was reasonable to detain was that there was no general pre-convention exemption. Power to inspect. You need me to... I'm going to wrap up pretty shortly, I think. Power to inspect is also, I think, a crucial part of enforcement powers, and also subject to some judicial interpretation. So Section 14 says that an officer has a power to inspect a place, and if the officer has the power to inspect the place, has associated powers to inspect documents which may be found there. Provisions interpreted in Leong, a recent decision out of BC. Leong is importing live corals. The corals are detained at what's called a sufferance warehouse, which is, I assume, just where you go to pick these things up. And Leong shows up at the warehouse, and as it happens, he's carrying some documents. These weren't documents that were accompanying the specimens, but he's just hanging around there with documents. So the relevant customs and EC officials say, we'd like to see those documents, and effectively compel him by saying, you don't get these things unless you give us the documents, gave them the documents. And the question was there authority under Section 14 to compel the sharing of those documents? And the court says no. The court says no because you only had a power to do that as an ancillary part of this power to to inspect a place. You didn't need that power because this was actually occurring in a public place, not a private place. So I think what's the importance of the case? I think it just illustrates that the Crown's got to be careful in the exercise of these powers. The offence provisions talked about this morning, and yes, we emphasised most are due diligence, with the exception of a strict liability rather than mens rea, with the exception of Section 8. Clement is interesting, actually, on the due diligence defence, because it's an example of someone trying to say, this Alberta hunter, I was duly diligent because I hired a guide and I followed the guide's advice. And the court's short answer to that is, that ain't good enough. You have a duty independently to satisfy yourself of compliance with state laws. So final substantive slide, just to emphasize that in addition to WAPRETA, one should be aware of the provisions in the Customs Act, which would provide those relevant officers with additional and sometimes overlapping powers. And concluding slide, just emphasize WAPRETA and the regs implement CITES domestically, but go beyond that. They reinforce provincial laws, but also can be used to protect biodiversity values. And yeah, I think that's probably quite enough. Thank you.
Thank you very much. Thank you, Nigel. I think actually that was extremely useful supplement and complement to what we had this morning. We're now going to hear a quite different sort of regime, one that you all know about, the Atlantic bluefin tuna. We talk of little else in Calgary, as you know. And we'll have Philip Saunders speak to that.
Kill myself here. Okay, let me just get the appropriate. Right. Okay. I guess I have to stay close to this and not wander like I usually do. Sorry. This topic is in a little bit of an in-between ground because to get to the enforcement part of the issues surrounding migratory fish stocks, I will be speaking about both the international regime and to a lesser degree some of the domestic regime that implements that international law in Canada. But the two are so closely connected, it's impossible really to separate them. Let's see if this works. This doesn't work. Try this. There we go. Okay, so the Atlantic bluefin tuna, which after consultation with my colleagues in marine biology, I'm assured is a fish, and they try to keep it at that level of knowledge for us, but I managed to extract some other details from them. The bluefin tuna is one of a range of large tunas ranging throughout the oceans. It's one we're going to focus on here. It's a large migratory pelagic species, crosses huge distances of open oceans. Its range can be from quite far south up to the Arctic, recently increasing numbers appearing off Greenland, for example, possibly due to climate change. We know that the spawning occurs in the Gulf of Mexico and in the Mediterranean. And in recent years, we've started to discover, which is kind of shocking given how long it's been exploited, that there were other spawning grounds further north in the Atlantic along the US coast. One ground identified initially, and then another, which throws into some doubt some of the decisions being made about stock assessment for things that turned out not to be the same stock. And these are fairly recent discoveries. It can migrate from tropical to cold water environments, 40 to 50 miles an hour, I think, is the sort of range. There are stocks in quotations in the eastern and western Atlantic and in the Mediterranean, but it's been found as well that they mix in feeding areas, if not in the spawning areas themselves. So very complicated scientific background to the management of this as well. We also have a later maturity in the Western Atlantic, apparently 11 to 12 years versus 4 to 5, which has significant impacts on the management regime and how much of the spawning biomass remains. The bluefin tuna has been fished for millennia in the Mediterranean and the Eastern Atlantic. It now includes, and I'm not going to give the details of the industrial development in the last few decades, but includes a catch and fatten fishery, and that you bring these into pens and fatten them, quite a degree of subsidization. The value, the highest value, is in the sashimi markets, which was always dominated for many years and still is by the Japanese market, but has expanded into other markets as well. In a recent sale, just I think in January, from the Tokyo fish market of a Pacific tuna that was caught, 283,000 pounds for one fish. These are significantly valuable fisheries. The age of this fishery, there's a time series on catches that was kept in a monastery near Cadiz, between the 1520s and the 1750s. At the end of that period, one of the monks, a Martin Sarmiento, wrote to his duke and said, catches are down over recent years. This is the level of attention they were paying then. And he attributed it to overfishing, but also thought there might be some issues with climatological change. It gives you an indication that everything comes around again. In the Western Atlantic, the commercial fishery was more recent in origin. There was an introduction of Japanese fleets in the 1950s, phased out largely by the 70s, but still some industrial fishery. But historically, it was a sports and recreational fishery, and the charter boat sport fishery is having a bit of a resurgence as well. This is interesting because it raises questions about the appropriate management approach. Are you treating this as a wildlife game sort of species, or are you treating it as the industrial commodity species that most of the fleets in the Eastern Atlantic do? This used to be a very big deal in Nova Scotia in the 30s and after. It was on, be broadcast on radio into the States. People like the Roosevelts and others would come up and fish off places like Westport as part of the international tuna competition series that ran in various places. And you can see photos of the time of the Greek team, the Mexican team, and from all over the world. This is one of the Bloomingdales fishing off Nova Scotia with a very large catch. This is just a sports fisherman who was well known. These are catches in the 20s and 30s. And this one here, 1979, in Olds Cove, Nova Scotia. Olds Cove, Nova Scotia, 1,496 pounds, the largest caught on record and confirmed. So significant. This is the other end of the industry at the fish markets in Tokyo and the auctions that take place. Now, as you see, lots of the fish are smaller fish as well. This is not all the giants. The giants are a declining part of the available biomass. Now, really shortening the history of the decline and fall of these stocks, but the catches peaked around about 1996, thereabouts, for the Eastern Atlantic and the Med, through the industrialization of the fishery and also a complete lack of management, subsidization, government encouraging fisheries. The triangles are the total catches, the black boxes, Eastern Atlantic, the Mediterranean, the little sort of diamond shape, and the white squares are the Western Atlantic. So you see it was never as big a component of the catch. But it did expand from the 70s in the West, declining rapidly from what it had gained after the 1990s. Now, what are the management challenges for this stock? Well, the key challenges pre and post the development of the UN Convention on the Law of the Sea, which we'll just be calling LOS or UNCLOS, in 1982, which gave jurisdiction to coastal states over 200 nautical mile zones, left some problems. One of the problems was the lack of any plenary jurisdiction in any one body or any one state over the range of species like the bluefin tuna, because they range so widely and go through so many different state zones that the expansion of the exclusive economic zone didn't provide the jurisdictional authority to take control of the management of these species and its enforcement. So any analysis has to take into account that complex regime that emerged and the fact that without somebody having jurisdiction, you end up with a lack of management measures, no significant enforcement. This is a common problem to many highly migratory stocks around the world, and it was left, I'll come in a moment, as a bit of a gap out of the law of the sea. But as a commercial and a recreational fishery, again, do you manage this as wildlife or do you manage it as a commodity, as an industrial enterprise? You also have continuing gaps in the scientific knowledge, surprisingly perhaps, or it's continuing to grow. But you also have a growing concern about the impact of climate change on these species, so this species included, with respect to both its range and its possible productivity of the biomass that you're measuring. Now, transboundary is sort of a general category. I just want to specify a little bit that quickly two of the legally relevant categories under the law of the sea out of the 1982 convention. You have joint or shared stocks, that is crossing over a boundary between two states, occur within the EEZs of two or more, and there are provisions to deal with that. You had the straddling stocks, so-called, which occur in an exclusive economic zone and in the areas beyond it on the high seas. And those, of course, led to massive conflicts, such as the one we experienced on the East Coast with the European Union and particularly Spain, who were exploiting at that time, well, various species, but in particular, as I call it, the lowly turbot that they hadn't really been interested in before, or Greenland halibut. And that's the Esti, which we confiscated beyond 200, and it was the poster child for bad fisheries practice. Had a phony bulkhead, a phony hold, and 2 sets of logbooks as to what they'd been catching, for example. And that's Brian Tobin, I had labeled him the conqueror of the Armada. He's the one who sent the forces out to go after the Spanish fleet, and everybody was very excited for a few weeks. The third, and the one we're concerned with, highly migratory species, which are defined, it's quite a number of them. I mean, not just tuna, obviously, there's swordfish and various others, but they're defined in Annex 1 of the Law of the Sea Convention. And essentially, they range through multiple exclusive economic zones and high seas areas. The convention dealt with it in part. Article 64 set up a system whereby coastal states and fishing states, as in distant water fishing states, were to cooperate, including the establishment, if necessary, of international organizations or arrangements to try and manage the stocks. Now, everybody read the part of Article 64 they wanted to read. The Americans, the Japanese, Taiwanese, and others read it very much as we can go fish where we want, and the cooperation is a secondary issue. This led to a great deal of conflict, parts of the South Pacific, where I was working on tuna issues at the time, and all around the problem of jurisdiction at that point. So we had the conflict in various regions. Then that duty to cooperate was given fuller form in a follow-on agreement, an implementing agreement, the UN Fish Stocks Agreement 95, which was also dealt with straddling stocks. Canada was very successful in pushing that, partly because of our experience on the East Coast with NAFO, the management organization in that area, and not entirely, but largely centered on the notion of regional fisheries management organizations, or RFMOs, as the locus of the jurisdictional control that would assist in taking some control beyond specific areas of national jurisdiction. So we take as I call it, a walk down memory lane. Don't forget, the Law of the Sea Convention was a negotiated document, one of the first, in some ways, of a major comprehensive, partly environmental treaty. But it imposed, in fisheries, very much an exploitation mindset, not a conservation mindset. The coastal states, to determine the allowable catch, shall ensure proper conservation, yes, but Its management measures should be designed to maintain or restore stocks at levels which can produce the maximum sustainable yield, as qualified by relevant environmental and economic factors, including the economic needs of coastal fishing communities. I'm not sure how a biological concept, maximum sustainable yield, is qualified by the fact that I would really like to take that species, even though the biological analysis would suggest otherwise. And the coastal states are to promote the objectives of optimum utilization of the living resources. This was the balance between, just as in shipping, between states that wanted to use these resources and areas and the coastal states that were trying to take more control of them. So, an exploitation-oriented approach, it enshrined a particular scientific methodology, total allowable catch, maximum sustainable yield, which was a methodology of that time, the late 60s into the early 70s, while simultaneously neutering it by suggesting that it could be qualified by economic factors and the desires of fisheries development. It was also predictive in its orientation, unsuccessfully as it turned out, because developed industrial fisheries required the ability to project into the future so they could essentially monetize something that they're given by way of quota or otherwise. Limited concern for what was to emerge in UNCED about sustainability. They're really treaties of two different eras. Question is whether we've moved beyond this. I'm not going to spend much time on this, but the UN Fish Stock Agreement was a post-UNCED agreement, and it does list principles, including precaution, protection of biodiversity. But it also, in a non-hierarchical list in the treaty, measures shall promote the objective of optimum utilization again. Measures are to be designed to maintain, restore stocks level of maximum sustainable yield as qualified by the relevant environmental and economic factors. And the precautionary approach, which I won't touch on just now, is defined in a way that is extraordinarily limited. So it didn't do quite what it was supposed to do. Which brings us to the International Commission for the Conservation of Atlantic Tuna, which was a pre-existing organization, but essentially one of these, effectively a regional fisheries management organization. Colloquially known in its bad days as the International Conspiracy to Catch All Tuna. Its primary international management body for Atlantic bluefin tuna and about 30 other species. It operates within the framework and limitations that I've just discussed for the Law of the Sea Convention and the UN Fish Stocks Agreement, and has about 52 contracting parties. Had a convention, was agreed in 66, fully established and in place really by the 70s in response to growing concerns about overexploitation of stocks in that period. Scope is all the waters of the Atlantic and adjacent areas, including the Mediterranean, and its mandate was to cooperate in maintaining populations of these fish at levels which will permit the maximum sustainable catch. They're not even calling it yield at this point. And that's the ICAT zone of operation. Massive. I won't spend time, these are just the governing bodies. There's a commission, which is the members of the parties. The important ones are the Standing Committee on Research and Statistics, which carries out a lot of work on stock assessment and related matters, a compliance committee, and 4 species panels dealing with different areas of tuna, tropical, temperate, and other. Over the years, ICAT eventually put in place management measures, things like recommending total allowable catches for the stock and allocating it among the parties, which was their key function, recommended size limits, some area closures, and on the enforcement side, monitoring, control, and surveillance measures, including proper vessel registry, port inspection standards for landed catch, that sort of thing. And they establish a boundary for their management measures between the east and western stocks, and I'll turn to primarily the western. They did eventually, after the complete collapse, establish multi-year recovery plans for rebuilding the western and eastern bluefin stocks. Originally adopted in 98 for the east, 2006, they included longer-term quota forecasts, which they hadn't done before, seasonal closures, adjustment of size limits, closing direct fishing in the Gulf on a lot of pressure from the Americans to protect the Gulf of Mexico to protect against interference with spawning grounds. The results, largely a failure for many, many years. Precipitous declines in stocks since the 70s, even after the rebuilding, although there's been some recovery in recent years. An independent panel review report in 2008 referred to it as an international disgrace. This was their own review panel. Basically they've been entrusted with the management of this iconic species, and the countries deserve better performance than they'd received to date. So pretty scathing. Why? The usual for international fisheries organizations. They ignored optimistic total allowable catch and went beyond them, the recommended ones. 2006, they recommended, the scientists recommended 1,500 metric tons in the Mediterranean. The Commission adopted in 2007 a rebuilding program, which put it at 29,500. The decision-making by consensus and the proliferation of objection procedures prevented real management, and a serious problem with non-compliance of some of the contracting parties who simply didn't report, didn't collect data, and didn't enforce on their own nationals. In recent years, the Eastern Atlantic and the Mediterranean, these are the quotas awarded in 2017, will see an increase, 28,200 tons this year, up to 36,000. They're just coming up. They're still partway through a rebuilding program. But the Western Atlantic has remained stable and is subject to monitoring year over year, but it's only at 2,300 tons, with the Canadian allocation being only 515 tons out of that. There have also been efforts to modernize the convention, which are still awaiting progress. In Canada, what do we have left? Well, we've got about 750 licenses. Gulf of St. Lawrence, the Scotian Shelf, Bay of Fundy, Newfoundland and Labrador. Some of them with very small volume, like down to one fish. Some people have tagged for one fish. But it's very lucrative. You've had one case where the woman was prosecuted for 70 fish that had grossed over about $1 million. So you can do quite well if you get the right fish. It's allocated, this catch, among 7 geographically defined inshore fleets, 1 offshore fleet. Actually, I think it's only 1 license holder, and doesn't get much of the allocation. And there are additional Aboriginal allocations, some other fleets allowing for bycatch in longline fishing and the like. The management is done through, as typical for Canadian fisheries, an integrated fisheries management plan, which is last done in 2008, but gets updated. Not enforceable legally, but still there. It includes enforcement measures under the Fisheries Act, which basically, if you violate the terms and conditions of your license, the minister can take your license away, they can suspend it, they can prosecute you for not meeting the terms and conditions of the license. They've got a full suite of enforcement powers available. And they've got these Section 79 penalties under the Fisheries Act, which if turns out you recovered monetary benefits from your breach, they can add that on to whatever fines they've given you. In one case, they added on $640,000 based on the value of what had been taken illegally in bluefin tuna, on top of several $100,000 of fines. The measures included in the fisheries plan include gear limitations and closed seasons, but there are also important monitoring, control, and surveillance measures, observers if requested, dockside monitoring, which is critical because these things have to come into auction to be sold, the bigger ones, and tagging of the catch. You get tags, and if you have fish on board and you don't have the tags for them, it's a violation. And catch documentation, which has been a major part of the issue, and prohibition of transshipment at sea. I'm almost at the end. Penalties can be significant. As I mentioned, the Zappa 1 case, which is not the biggest by any means, taking tuna beyond their allowance in a catch and release sport fishery that they were engaged in. They had suspensions of their licenses for up to 5 years for a few of these people, and fines up to $30,000 to individuals, not corporations. This is the Zappa 1 here, and they also can use the Section 79. This charming individual here, riding on a dead bluefin tuna, is the American sportswoman who had chartered the boat, was supposed to be doing sport fishing. She was never alleged to have committed an offense or charged. They had the licenses. That's her riding on the back of the bluefin that they've illegally killed with a bottle of champagne. So she's up for the Donald J. Trump Sportswoman of the Year award for next year. We also, just briefly, we'll mention the SARA designation, almost done. In Canada, following on from previous efforts at CITES to get bluefin tuna designated under CITES, which didn't work, Canada and others fought it, and in the US where they tried to do it under endangered species and failed. There was a proposal in 2011 in COSEWIC, Committee on Status of Endangered, whatever, in Canada. There was a proposal to designate under SARA. That didn't get dealt with until this past year, but there was overfishing, argued a 69% decline in stocks over 2.7 generations, habitat destruction in the Gulf of Mexico because of the spawning grounds in Deepwater Horizon, and allegations related to seismic and sonar. That designation was finally rejected in May of 2017. The focus of the rejection was on socioeconomic impact of a small but economically important fishery to certain communities, including an Aboriginal fishery, and an argument that the new ICAT assessments of the state of the stock were improved, and a promise to update the IFMP any day now, including a review of the onboard observer coverage for enforcement. And it's possible, I think the argument was, that you don't really impact this stock very much by a Canadian SARA designation when most of it is managed and exploited elsewhere than in Canada. So, primary problem remains, in my view, at the international level, because you need serious management policies to enforce. We haven't quite gotten there with ICAT, I don't think. And an associated lack of state enforcement by some parties to the convention, worse for the Eastern Atlantic. At the national level, I think the enforcement of the fishery as structured in Canada is feasible. Low numbers of fish, fairly easily tracked. They have to bring it into auction. There are identifiable places where you bring it in and you have to report it. Would the SARA approach markedly improve on that in terms of enforcement? I don't think so. Given the overarching international issues, you probably have a doable enforcement system if it's fully carried out. The science remains a problem, lack of full knowledge of the stocks, and that's supposed to be dubious methodologies, we can talk about, and a coming impact of climate change to a degree that we aren't even sure what it's going to be. I'll stop there.
Thank you very much. We've been very good with our time, and we now have time for questions of either or both speakers here. And while you're thinking about that, I'm going to ask one. One thing that came up in both the talks had to do with basically keeping science contemporaneous with the law, I think, in a way. That comes up in terms of CITES meeting every 3 years and amending lists. That's one technique. And then, Philip, you've raised a number of issues relating to, if you will, the awkwardness sometimes of international regimes in terms of managing changing scientific consensus. And so I guess I'd like to hear first maybe from you, Nigel, about how you perceive CITES in terms of its performance. Are the parties generally happy with this other 3 years, or maybe it's not the parties we should be talking about, maybe we should be talking about NGOs. And then, Philip, if you could add your comments about the fisheries management and the degree to which that's an issue there.
Thanks, Owen. So, is CITES working from the perspective of the parties? I think it's acknowledged to be one of the better MEAs. The parties need to meet more than every 3 years? I think probably not. There's background work going on in 2 committees, the Animals Committee and the Plants Committee, and then there's a standing committee which deals with more administrative stuff. I think probably the focus actually has to be on compliance, right? Rather than, I mean, sure, I think the listing process is going to be informed a lot over the next couple of decades by climate change, right? That's going to be the big driver of new species being added, and you can see that in an Arctic context, and you can see it in the Endangered Species Act listings in the United States. But I think the focus has got to be more on bringing effectively forms of trade sanctions against countries that aren't complying with their CITES obligations as particularly states of import.
Okay. Before Philip answers, I wonder if maybe the success of CITES is because it's so specific, as opposed to having general terms like precautionary approach and so forth. It's very specific in terms of a list and so forth.
Well, I think the other reason is it focuses on trade, right? It's not concerned with the hard stuff in a sense, which is protecting biological diversity on the ground in the states of the contracting parties. So the convention that does that internationally is the Convention on Biological Diversity, which is characterized by some of the most general best efforts language of any treaty that there is out there. So CITES can be hard because it focuses on something which really is international rather than at home.
And it's narrow.
Yeah.
Yeah.
Yeah, it's an interesting problem, and I think the Law of the Sea was a particularly bad example because it was negotiated during a period where hubris was not a real concern. They believed that science was at its peak, and we now had all the answers, so we could put it in a treaty. And what we did in the Law of the Sea Convention was put in a permanent treaty, which is incredibly difficult to amend, not scientific objectives or anything, but actual scientific methodologies of the time. And that's not how scientists work. Scientists come up with a theory, all the other scientists make fun of them for a while, and eventually they get another version of it, and it changes over time. But we've enshrined a simplistic view of the notion of maximum sustainable yield, which has been pretty largely debunked, and it's as if we were going around, wearing nothing but the clothes that we wore in 1968. Because that's about when the system was, and some people are old enough to go, oh dear, the system was current. We need to think more about the results and avoid the binding legal obligations being tied to a methodology. Think it more about its adaptability, and that's going to become an even bigger problem with climate change because total allowable catch and maximum sustainable yield is based on the notion that you can project forward from the history. And if everything that you have from the history is now being altered significantly by climate change, and in some cases it is, on productivity, on range, on disease vectors that suddenly appear, all of that is going to change the calculation. So the data you had from before, which was the basis of everything, may not be any good. So I think there's a real danger in enshrining things too hard a form.
Although I must say that I wouldn't mind see you wearing your orange paisley shirt from 1968, but that goes.
That tasteful blue collar as well.
Anyways. Oh. Well, if you're still chewing, I did want you actually, Philip, to expand on something you referred to, and that is managing the sort of trying to decide whether you're managing it as wildlife or managing it as a commodity. And I wonder if you could speak a little to the implications of what you meant there.
Yeah, there's some middle ground, but this is a species that has both sides to it. It's iconic. It is used in a sport fishing context we normally think of as game. That's what it was, and the management then would focus on a fairly small number of operators and boats and not very significant impact on the stock through a game fishery where what you're trying to catch weighs 1,000 pounds with a rod and a reel. But the dominant model in the Eastern Atlantic and the Mediterranean was that always an industrial, even pre-industrial, a fishery for food. And so you're talking about it as biomass, not individuals in a population. depending on the type of tuna, you get both. I mean, the albacore and the skipjack and others are more in the large numbers, easier to manage that way. Southern bluefin tuna of Australia, they said at one point they were just going to manage them by giving each one a name and be done with it, because the numbers were small enough. But I think that if you're in the model of a fishing organization, which is what ICAT is, it's a fishing and fishery organization, not a fish conservation organization. That somewhere in between you have to find a better model, and I do think the rod and reel approach, and rod and reel or tended lines, one hook, in the Canadian context is a much better model for that, but you could never sell that in the Mediterranean.
Okay. Yes.
There was an online question.
And
for,
online. You'll need a mic.
Thank you. I received a question online from our viewers asking if there's a citation for a legal citation for the Zappa 1 case. And I don't know if that...
it was unreported. I just got, I based it on press reports. But once the paper's in, we'll have a site to the website for that. It's CBC. If they look at Zappa 1 and CBC, you'll find it.
Okay, thank you.
Okay. I have more questions. Nigel, one of the things that was mentioned this morning, not just in the context of SARA, but our wildlife legislation generally, is that it tends to be non-criminal. Well, it isn't. It's largely non-criminal. And there are advantages to that in terms of proof and so forth. I don't know, and you may well, whether or not other countries also uniformly take that approach. For example, I'm not sure if the U.S. qualifies CITES implementation as criminal law or not.
I don't know.
Yeah.
I was struck by the Canadian example, which had a U.S. counterpart, and struck by the money laundering charges which were levelled, which I guess was a way of criminalising what was a trafficking example.
Yeah,
But beyond that, don't know.
I use money laundering charges for a lot of things these days in the States, I guess. Yes.
There's a Article 24 of the United Nations Declaration talks about the conservation of traditional plants, animals, and minerals. And I'm just wondering how that might fit into a legal or regulatory framework, keeping consistent with Canada's goal of implementing the declaration.
So I'm actually not sure how to answer that. I mean, certainly there are traditional knowledge inputs, for example, into decisions made regarding harvestable polar bears, so co-management arrangement in Nunavut, the heavy involvement of the Nunavut Wildlife Management Board in assessing, which is established under the Nunavut land claim. So strong involvement in management decisions, but the particular reference to Article 24 was to what? Can you remind me of?
The conservation of traditional plants, animals, and minerals.
Medicines and stuff.
Yeah, I'm not sure that I have much to add to what I've already said. I don't know whether there's anyone in the audience who wants to speak to that. And again, traditional knowledge involved in SARA listing decisions.
Environmental assessment?
I know they've folded traditional knowledge into the COSEWIC process a little bit.
Yeah.
Part of that, I'm not sure I heard it all, but if it's the substances, like the plants themselves and their traditional uses rather than knowledge about them, some of that crosses over into sort of the intellectual property debates about the appropriation of those sorts of substances as well. And so it could be partly in that front.
Okay, well, we have finished pretty much exactly on time. So I'd like to thank the speakers and